Hello everyone, welcome to another one of Exploration Group's Music Industry in 5-minute or less video series. I'm Renee Meredith, and today I'm going to be discussing what are the exclusive rights to copyright owners as granted by the copyright law of the United States. This discussion is only going to apply to the copyright law of the United States. Check out your own copyright law for your territory to understand the same types of rights that you might have as a creator where you live. There are 6 basic rights granted to a copyright owner. Under copyright law, an owner can do or authorize someone else to exercise these rights. There used to be 5 basic rights, and many copyright lawyers and classes still refer to the first 5 as the basic exclusive rights, but there are in fact 6. They are laid out in Section 106 of the U.S. Copyright Law. And here they are. Right number 1, to reproduce the copyrighted work. This means to make copies of a piece of art or a photograph, or in the case of music, to make copies of a sound recording from the master recording. In the case of a composition, this can include making copies of sheet music or recording performances of the composition. Right number 2, to prepare derivative works based on the copyrighted work. This can mean that an artist adds or takes something away from a sculpture. It also includes taking a sound recording and remixing it or sampling it. You have to have the owner of the original's permission to do this. In the case of a composition, it means using the melody, lyrics, or other unique portion of the composition and using it in your newly written song. The sampling of a composition is often called an interpolation, and you still do need the copyright owner's permission to do this as well. Right number 3, to distribute copies of the copyrighted work to the public by sale or any other transfer of ownership, or by rental, lease, or lending. This could be when someone takes a photo or a piece of art that you've published on social media and makes prints or copies or t-shirts and distributes them to the general public. They don't have to charge for them. Even if they're giving them away, it is still an infringement upon the rights of the creator. In music, it's always been understood that making a copy of something for your own use was okay, but you cross the line when you make multiple copies or enable distribution of that music to the masses without permission of the copyright owner. Perhaps the most infamous example of this was the early days of the website Napster. They're now legit, but in the early days of the platform, it enabled people to upload copyrighted material, and visitors to the site could download that material for their own. This is considered a transfer of ownership. Right number 4, to perform the work publicly. This right applies specifically to literary, musical, dramatic, choreography, pantomimes, motion pictures, and all other forms of audiovisual works. This could be seeing a movie in a movie theater or on Netflix. It could be reading a literary work on stage by a performer. It could also be your favorite band performing on a live concert. But what about artists performing concerts live and covering other artists' songs? Or any other artist performing a song where they aren't the songwriter? The license that covers this right is usually obtained by the venue where the musicians are performing. Broadcasters of film and TV and radio also need to get a performance license. Online platforms such as Spotify, YouTube, and Pandora also must get a performance license. In the United States, these licenses are obtained through PROs like ASCAP, BMI, CSAC, and GMR. Right number 5, to display the work publicly. This right applies to literary works, musicals, dramatic works, choreographed works, pantomimes, pictorial works, graphics, sculptural works, and individual images from audiovisual works like films, TV shows, and music videos. To display a work can refer to one or more images of a work, such as a scan of a page from a book, or it could be a photo taken by a photographer at a sporting event. It could also be the display of a sculpture or a painting in a gallery. Right number 6, to perform the copyrighted work publicly by means of digital audio transmission. This right applies to sound recordings, as they may appear on digital streaming platforms like Spotify, YouTube, or Amazon Music. The consumer isn't taking ownership of any type of digital files, but they are able to listen to the music. This includes both interactive and non-interactive streaming. These are the 6 exclusive rights for copyrighted works in the United States. For more information about this topic, check out the links in the description below. As always, thank you for watching, and don't forget to hit subscribe for more videos from our channel.